again. This is a purely legal presentation, and I would like to thank, in the very first place, Dr. Chen Asma for allowing me to have a second presentation. This is going to be a focus on one of the challenges that were already presented in the previous presentation. So why did I select to talk about legal aspects in CubeSats and space debris issues? The wide-ranging improvements in CubeSat technologies towards smaller, faster, better, and cheaper solution is a fact acknowledged by many in this room. The aim of this presentation is to raise your awareness in the consequences deriving from the increasing launching of CubeSats when it comes to safety and sustainability of outer space activities. This is endangered by the launches taking place out of the proper and legal and regulatory procedures, especially in countries that do not have in place any regulatory systems, meaning operations taking place outside of the law. The issue that I will particularly address are the space debris mitigation guidelines that have to be followed in case of risks posed by CubeSats. So the outline of my presentation, I will give you a brief overview of the international space law. I will talk to you about responsibility and liability in outer space, the present risks that were faced from the launching of CubeSats, the space debris mitigation guidelines, and then I will proceed to my conclusions. International space law, Corpus Juris Spatialis, as we lawyers call it. It comprises of 5 space law treaties and 5 United Nations General Assembly resolutions and guidelines. They are all issued by the United Nations Committee on the Peaceful Use of Outer Space. The UN Corpus is subdivided into two other subcommittees, which is the technical, scientific, and the legal subcommittee. From the 5 space law treaties that you see in the screen, the most important thing that you should remember after this presentation is that the Outer Space Treaty has been ratified by 103 states. And this is a very big number considering that the United Nations member states are 199. The Moon Agreement, on the other hand, is the least acceptable from the space law community, since it has been ratified only by 13 states, which shows the reluctance of states to be bound by any legal restrictions on the regime governing the Moon. Moving to responsibility and liability. Responsibility of states is regulated under Article 6 of the Outer Space Treaty, and it provides for their responsibility on national activities carried out in outer space by governmental and non-governmental entities. The definition might sound clear to you, but it is not the case. National activities are not defined under the Convention, and it's a term subject to interpretations at the national level, which means that every state can decide if an activity taking place in outer space is a national activity or not. For instance, Belgium considers the operation and launching of CubeSats a national activity, and they consider themselves to be responsible for this operation. On the other hand, the Netherlands, they consider CubeSats not space objects, not a space activity, because they cannot be maneuvered, they cannot be controlled. So, since they cannot be controlled, they cannot exercise authorization and supervision, which is the next obligation under the Article 6 of the Outer Space Treaty. So they don't want to have anything with responsibility under this article. And I would like to mention as an example, like the ICE is a nice mission that I don't remember when it took place, but the Netherlands did not approve the mission as a responsible state, but they only gave a letter of consent, which was not so official. But in any case, they want, it's one of the states that they don't want to be held responsible under space law. So the states have the obligation to authorize and supervise, and this, most of the times, is accomplished through licensing. This is not the case, again, for all the countries, because some countries are more developed on the space law than others. So we have the countries that have extensive requirements and onerous condition on the licensing, and others that do not have any requirements at all. But that doesn't mean that they are not obliged to authorize and supervise. Another obligation coming from the Registration Convention is to register the space objects in the national and the United Nations registry. This is very important because of the information provided thereof. They're available to all the public, and it's like, I would say, the ID of a space object. And I'm not aware of how many people in this room that are involved in the development of CubeSats and the operation are registering these space objects. But it is very, very essential. Article 7 of the Outer Space Treaty provides for jurisdiction and control over the registered space object, and also liability of the launching state. The launching state cannot be only one. There can be 4 different launching states, according to the Article 1 of the Liability Convention. So we can have the state which launches, the state that procures the launch, the state from whose territory or facility the space object is launched. When we have 4 different launching states, then the 4 of them or more, they have to decide which is going to be the state of registry. Because the state of registry, as I mentioned, has to exercise jurisdiction and control. And this is very, very important for every space mission. For instance, in the QB50 mission, we have a lot of launching states due to the different actors being involved, but they have to decide themselves who is going to register. Talking about space object, there is no doubt that CubeSat falls under the definition of space object, and that the international space law applies to CubeSats. There is no restriction concerning the size or the mass that could limitate this application. The liability regime under the Liability Convention is divided into levels. We talk about absolute liability under Article 2 when there is damage on the surface of the Earth or on aircraft flight, which means in this case that we don't have to prove fault, but we only have to see from whom the damage is caused. And we had this morning very interesting presentations on assessing ways how to make possible the re-entry of CubeSats, and how that could probably cause damage on the Earth. What I would say is that if we have damage, you're going to be held absolutely liable. You cannot deny this. So you have to be very careful with any assessments when it comes to damage and to risk of damage. When we talk about damage in outer space, then it's a fault-based system, and then we have to prove fault. This is the case for most of the CubeSats launchings, as they can pose a risk in on-orbit collisions. The Liability Convention provides for limitless liability of states. States, though, have the right to recourse to the operators, and they can purchase insurance. The problem is that the insurance for small satellites has not been yet enacted. So it's quite of problematic about the operators, what should they do? Well, there are some countries like the US, for instance, that they are planning to abolish any requirements for insurance, for CubeSats, or for licensing, but that's not something definite, they're just talking about it. But why are we mentioning all these legal issues? What are the risks we are presented from the launching of CubeSats? Well, the amount of space debris already has been increased after the Iridium Cosmos collision, as we all know. And during my research, I was amazed that the first collision between space object and space debris was a small satellite, a microsatellite series. And then the most recent collision is Blitz, which collided, as you can see in the picture, with a fragment of the anti-satellite mission of China. This for me shows that even if it's small, CubeSat is small, and space is big, we shouldn't think that there are no risks posed by from the launchings, especially in the sun-synchronous orbit where we have most of the launchings taking place. I also consider the constellations, the CubeSats launched into constellations, posing another risk due to the fact that the CubeSat is already very small to be traced from space situational awareness programs. So my question to all of you is that would it create a bigger problem if it's part of a constellation? Would it create any confusion on these programs on how to identify which CubeSat is what in all these big missions like the QB50? But it's just a concern I personally have, so I would like to share this with you, and we can have also a more extensive conversation later. Space debris mitigation. We don't have any hard law. We don't have any binding legal instruments regarding debris mitigation guidelines. We only have soft law. The guidelines are not binding upon states. They only recommend what states should do, and if they want, they will follow them. The first guidelines were introduced by the IADC in 2002, and they were enhanced by the UN COPUOS in 2007. What is interesting that guidelines do not focus only in one phase, but they are referring to the operational phase, to in-orbit collisions, to limitation of the presence of the spacecraft in low Earth orbits, to 25 years. And well, most of you have mentioned in previous presentations that the CubeSats are going to be launched for a very short time mission. But again, my question is, when it's launched above 600 kilometers or around 900 kilometers, what are the chances that it's going to stay for such a short time? Because we also have CubeSats that have been launched so far, and they are there for 11 years or more. And this is a concern about the congestion that has already been created in low Earth orbits. The debris mitigation guidelines have also been recently followed by the European Union initiative of the International Code of Conduct. In their provisions, they include the same guidelines because they want to emphasize the threat to sustainability of hyperspace activities, which is space debris and orbital crowding. Again, it's not hard law. It's only open to states upon voluntary basis, and there are many people arguing that it's not going to bring any change on the already soft law guidelines. But I would say that even if it's not hard law but it's voluntary, it still is important because states will be pressured in a political level, if not legal. And they will have to follow these principles because the problem of space debris is becoming more and more important. And also another thing is that we cannot wait for another space treaty to be concluded, since the process of adopting a treaty in the United Nations Committee on the Peaceful Use of Outer Space is through consensus. So if only one state does not accept, then the treaty will never be approved. So I would say even soft law instruments like the International Code of Conduct should be considered as a positive sign towards the limitation of space debris and the awareness of the states on this problem. At the national level, the application of the guidelines looks very challenging. On the other hand, it will be very effective. Very recently, France adopted on its domestic French space law the guidelines, which makes them binding. So all the French operators are bound by these space debris mitigation guidelines. And this is very positive. But the question is again, how many countries are ready to follow this practice? Coming to my conclusions, this presentation does not aim to prevent future CubeSat launchings. Of course we want CubeSats, but we want them to be launched in a safe way. We want them to comply with international space law regime. And CubeSat developers should take into account that the access to space is for all mankind and not only for mission. So they should take into account additional procedures of risk assessment for re-entry missions or for other missions, and they should register their CubeSats. Please do so. It is very important that you register them and that you follow the debris mitigation guidelines. Thank you very much for your attention.
Thank you very much. Are there any questions from the audience? A number?
So thank you for a very interesting and important presentation. So I have one question. Do you know any real cases where this liability has been actually realized and one country has taken the responsibility and compensated the damage he has made or it has made to another spacecraft or something?
Thank you very much for your question. Unfortunately, for lawyers, there are not any cases. I'm saying unfortunately because we want damage, because then we can find out who is responsible, who is liable. We only had the Iridium Cosmos case, which caused damage over Canada. But then the dispute between Canada and Russia was settled through diplomatic channels. They did not decide to go through the space treaties, and they did not decide to claim any compensation, because the problem was then that damage was not Canada did not suffer any property damage or any damage like bodily injuries or any casualties. So the only damage that it suffered was in the environmental damage, and that is not considered damage under international space law. So that was the reason that they could not claim compensation against Russia, and that has been the only case so far. And of course, it did not consider itself to be responsible.
There was another question. It's been answered. Okay, and we'll proceed to the next presentation. Thank you very much.